A man once named public enemy number one of the Metro Gang Unit in Salt Lake City is officially off the streets, convicted of brutally murdering his girlfriend in a crime so shocking even his own words may have betrayed him. Terrance Vos was found guilty of 5 first-degree felonies, including the aggravated murder of his girlfriend, Shandon Scott. She was shot 12 times, and Vos swore he wasn't the killer. But a recorded jail call may have caught him slipping, allegedly admitting he pulled the trigger. Now he'll likely die in prison. How did it all unfold? I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Before his conviction, Terrance Vos was already well known to law enforcement. According to KUTV, he was a known gang member and parole fugitive with the street name T-Bone. He also had a criminal record stretching back to his teenage years. In 2015, Salt Lake City police even issued this wanted poster for him, linking him to multiple drive-by shootings. But in 2021, while on parole, Vos was charged with something far worse, a crime so brutal it ensured he'd never walk free again. Prosecutors say Vos shot Shandon Scott at an apartment complex around 2:45 a.m. on May 1st. Just 15 minutes later, her body was found inside a crashed Ford Fiesta on the interstate. According to court records obtained by KUTV, a witness who stopped to help told police they saw Vos in the driver's seat, quote, freaking out before he jumped out and tried to steal their car. Well, he failed, and when officers arrived to perform CPR on Scott, Vos took off running, but not before tossing something over the overpass. That something? Investigators say it was a gun. Vos didn't get far. Police arrested him, and now he's been convicted of aggravated murder along with multiple firearm and obstruction charges. An autopsy on Scott's body revealed that she had been shot 12 times before the car crash. Vos denied killing Scott. He took the stand in his own trial. He testified that there were 2 shooters and the bullets that killed Scott were intended for him.
Oh my God, I just felt so bad. I just felt so bad because I feel like Shannon's life is more valuable than mine. I feel like she has more to live for. She had kids. I'm nothing. I'm nobody.
When prosecutors pressed Vos on who pulled the trigger, he claimed he knew but refused to name names.
What's the name?
I'd rather not do that.
You're under oath.
And I understand that.
But despite denying he was the shooter, prosecutors confronted him with a recorded jail call, one where he reportedly told a friend that he and Shandon had gotten into a fight and he shot her.
You tell Jen that she was stabbing you and that you shot her.
You say that.
That alleged admission sealed his fate. After a 6-day trial, the jury found Vos guilty on multiple counts, including aggravated murder, 3 counts of discharging a firearm with serious bodily injury, possession of a firearm by a restricted person, obstruction of justice, and failing to stop at an officer's command. Now, people on social media are saying justice has finally been served for Shandon Scott. According to her obituary, Shandon was a student, a cosmetologist, and a mother of 2. Loved ones described her as outgoing and full of life. She loved hiking, painting, traveling, singing, dancing, hitting the gym, and watching movies. And joining me to talk more about this is Utah attorney Sky Lazaro. Sky, thank you for coming on today. Let's jump right in. So Vos was out on parole when this incident took place. How does someone with Vos's criminal history and gang affiliations get released on parole in the first place?
Well, in Utah, we have an indeterminate sentencing structure, which means people get sentenced to a term. If they get sent to the prison, it's an indeterminate term. So it can be a 0 to 5 years or a 1 to 15 years. They serve some time pursuant to a sentencing guideline matrix and how they do in the prison. And then ultimately it's up to the parole board to, grant them parole. So in this case, he had done some time in prison, was granted parole, and then he's supervised by adult probation and parole during that period.
What kind of monitoring or restrictions are typically placed on parolees? And do you think the system failed in this case?
This case is interesting for a number of reasons. There's different conditions that AP&P and the Board of Pardons and Parole can place on people depending on their risk level. So it can be as stringent as ankle monitoring, curfews, treatment, those types of things. If I remember correctly in this case, he was placed on an ankle monitor, but for some reason he'd either failed to charge it or something along those lines at the time that this offense was committed because they weren't able to find him at the time.
Is there any legal recourse for the victim's family against the parole board or the system that allowed him to be released, or not really?
I think that'll be interesting. I don't know if the victim's family is going to pursue that. There was a number of investigative journalism reports at the time that he was alleged to have committed the offense before he was convicted that were pretty hard on the Board of Pardons and Parole and the Department of Corrections for failing, to properly supervise him and release him. We're in the 10th Circuit here, and we have what's called qualified immunity for law enforcement, judges, prosecutors, people who are acting in an official capacity. So there may be, some recourse that they could possibly pursue on the civil side. But the way the 10th Circuit's come back on a lot of these types of cases, I don't know how successful that will be.
And I guess, when looking at the suspect's criminal history, he had been in jail time and time and time again. I guess just for people wondering, was this inevitable?
I think that's always a hard thing to look at. And I do think that's something that the Board of Pardons and Parole takes into consideration when they talk about whether or not someone should be granted another release. We have a system where we don't lock people up indefinitely. We don't have, like a 3-strike rule like some states where, if you come back a number of times, you're done and then you're doing 25 years. And so I think when a lot of his history, while some of it is violent, and there was some shootings and other stuff involved for whatever reason, I think they felt that he, had done well enough in prison and taken the classes that he should be given a chance at parole. And that's, unfortunately, when something like this happens, it forces us to take a look at it, but you can't, necessarily make it a blanket statement either and say, just because you have a history, there's no chance that you'll ever be rehabilitated.
Now, let's talk about the trial. On the stand, Vos initially refused to name the shooter, but later allegedly admitted on a call that he shot Shandon. How do contradictions like this impact a case?
I don't think he did himself any favors testifying. I mean, that was conversation between him and his attorney. I watched some of his testimony and some of the cross-examination. And I think when you have someone like Terrance Vos, who is not his best witness for himself, just his mannerisms and his responses to the questioning and kind of making light of it. And then, he blames, points the finger at another shooter or 2 shooters. And then, they have these jail phone calls where he admits to doing it. I think those always play in favor of the state because I think juries are generally skeptical of defendants, just by nature of being a defendant. So when you have inconsistent stories such as this, where, you're refusing to name who did it, it's 1 shooter, it's 2 shooters, and then they have a jail phone call with a friend where he should have known he was being recorded, where he admits to it. I think that probably was a fairly compelling factor in the jury's determination.
And how common is it for defendants to incriminate themselves on jail calls? And why does it happen so often, do you think?
Far more than I would like. I think every good defensible case I've ever had has probably been lost over phone calls on some level. I don't know. I think being incarcerated is hard for people. no matter, they know they're being recorded, they're told they're being recorded, no matter how many times their defense attorney tells them, please don't make statements on the telephone. People just cannot seem to help themselves. And unfortunately, a lot of times end up, either admitting to crimes or engaging in witness tampering or other things that are really harmful to their defense.
And in your experience, how do defense attorneys typically counter damaging jailhouse recordings like the one in this case?
It depends how bad they are, and in this case, you try to maybe put things into context, because, I have had calls, or you hear of calls where it may sound like an admission, but when you look at it in context of what was happening during that conversation, perhaps it's not really an admission. And so I think trying to lay some context always helps. Unfortunately, in a situation like this, they're it's tough, and they're always going to be able to use the defendant's words against him in a trial.
And Voss reportedly ran from police and allegedly tried to steal a car at the crime scene. How do prosecutors use actions after a crime to prove intent?
I think the way prosecutors use that most compellingly is, to show a consciousness of guilt, maybe more than intent. I think sometimes you can use it to intent, but really what it just goes to is kind of this totality of the circumstances where, if he was really driving her to the hospital, why wouldn't he stay and render aid? Why wouldn't he call for help? Do all of those things instead of fleeing the scene, disposing of weapons, whatever it is that they engage in, talking to witnesses, to try to cover up or come up with some sort of alibi. And different people react to different situations differently. People panic, people freeze. Uh, in a case like this where you have someone who is on parole, who has a criminal history, who has a violent criminal history, the fact that, if his story is true that he really was driving her to get help, why don't you stay and try to help her? Why don't you call for help? Why don't you do something like that? And I think when you kind of look at it in context of everything else that came in during this trial, really what I think it goes to is really character and kind of a consciousness of guilt.
Yeah, you definitely bring up some good points there. And Terrance was charged with aggravated murder. What separates aggravated murder from other homicide charges?
So aggravated murder is the most serious murder charge that we have in the state of Utah. It carries possible penalties of the death penalty, life without parole in prison, uh, or 25 years to life in prison, whereas just a homicide without the aggravating factors carries just an indeterminate term of life in prison. So you do have the possibility of parole on a regular homicide. In an aggravated homicide, you do not, or potentially don't.
Can an appeal realistically change Terrance's fate, or is a case like this considered a done deal after a conviction?
I think it would depend on what issues are raised on appeal. If the trial court made problematic findings that an appellate court can come back and say, hey, the trial court ruled incorrectly on this piece of evidence or this objection, or something along those lines, and that's something that the jury, strongly considered as evidence of guilt or something, or should have considered other things as exculpatory that weren't allowed to be introduced, they can come back, they can vacate the sentence or vacate the conviction and send it back and say, you got to try the case again. Other things, prosecutorial misconduct is often alleged, ineffective assistance of defense counsel is often alleged, but they'd have to find harmful error in this case in order for it to come back for a new trial. And it wouldn't be over. It's not just they vacate the conviction and it's done. He probably would be retried in this case.
Given Voss's gang background and criminal history, would that play a role in sentencing, or is that legally separate from this case?
No, that would play a role in sentencing. So a number of factors go into sentencing in any case, not just this, but they look at a person's criminal history. They look at what they call pro-social and antisocial risk factors. So people's family, employment, community involvement, treatment, drug use, any history of mental health or things like that. So they will, especially in this case where he committed an offense while he was on parole for another offense, that's going to be a pretty serious aggravating factor in terms of sentencing in this case.
How often do defendants testify in their own defense, and does it usually help or hurt them? I know we touched on this a little earlier when you said that Terrance taking the stand maybe wasn't the best idea. Do you think the outcome could have potentially been different if he hadn't?
I think it depends on the case and the kind of defense you're running. I think there are certain cases where if you don't put on jurors they always want to hear from the defendant, right? Like, what's your story? And I think that really is dependent on the type of defense or strategy that the defense counsel and the defendant come up with. So there are cases where I think if you run certain defenses, if you're looking at a sexual assault case and consent's the issue, someone's going to have to get up there and say, I think, that this person consented. Or if he has an alibi in a murder case, he's going to have to get up and present alibi evidence that he wasn't there and he was doing something else. And the jury's going to have to find that credible. In a case like this, I think he probably would have been better off. I don't know if it would have made any difference based on the evidence that they had, but he probably would have been better off not testifying. I don't think his testimony in this case added anything helpful to him.
What's the biggest mistake you see criminal defendants make when they do take the stand?
A lot of times if people have made prior statements that they can use to question their credibility, I think that's always a problem. I think it's difficult for criminal defendants to get up and come across genuine. People are nervous. They often say too much. They want to explain away things like that, and not just answer questions posed at them. Another thing that's really difficult a lot of times, and this is why we work with, if someone's going to testify, you spend a lot of time working with them, is body language. Jurors and just people in general, we pick up on body language almost more than we pick up on words. So the way people speak, if they're articulate or or they come across arrogant or, above it all, or this, mad at the system, things like that. I think people stop listening to the words sometimes and they just, judge them based on, is this a person that I trust, or is this a person just up here saying whatever they have to get out of trouble?
Could the fact that Vos was on parole at the time of his murder lead to additional charges or a harsher sentence?
It likely will lead to a harsher sentence. It almost always does. So one of the aggravating factors really in all aspects of the case, from whether or not someone's detained pre-trial all the way through sentencing, one of those factors was the offense committed while the person was on probation or parole for another offense. So one of the probably worst things a defendant can ever do for themselves is commit a new crime where they're being supervised for a prior crime, because that's going to add, the parole board's going to look at that and say, we're never letting you out again, in this case, likely, or, it's going to add considerable time, even if we're not talking about something as serious as an aggravated murder. If they're committing offenses while they're on probation, while they're being supervised, they look at that and say, look, like you're such a huge safety risk to the public, that's not something that we want to take on again.
And lastly, I have to ask you this before I let you go. I know on the stand, Terrance refused to answer key questions. He said that he knew the shooter of he knew the person that shot Shandon, but he refused to say who it was. Hypothetically, after, he gets sentenced and he goes to jail, if he comes back and says, oh, I want to reveal who the alleged shooter was, will that work in his favor or no?
I think that's a tough one. I think we see this a lot in gang, especially in gang-related types of cases. Defendants are a lot less likely to name other co-defendants or point the finger at other people for multiple reasons. Sometimes they're afraid for their lives. Sometimes it's just a code of conduct that they adhere to as part of their affiliation with whatever group or gang. In a case like this where a jury's convicted him, if he comes back and names someone else, he better have some compelling evidence to back that up that would show actual innocence. It won't be enough just to point the finger and say, okay, I changed my mind. Now I want to tell you who it was. And quite frankly, even on the stand, if he'd named someone else with his prior statements, I don't know if that would have made a difference to the jury.
Great. Well, this is something that we will for sure be following. Thank you so much, Guy, for coming on.
Thank you. Thanks for having me.
Vos is scheduled to be sentenced in May. For Law and Crime, I'm Kennedi Walker.